you have any questions, sir?
No fucking nerves!
You're 21 and you have all these priors? What the heck, man?
Everybody perfect.
Don't say anything. It's a rhetorical question. 1, 2, 3, 4, assault, criminal trespass, attempted assault on a public servant, possession of a controlled substance, unauthorized absence from a correctional facility, felony retaliation, assault, felony assault, assault of a public servant, assault of a public servant, harassment of a public servant, assault of a public servant, now 2 counts of a burglary of a motor vehicle and a robbery. Something's not taking. Let's do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you. Please.
On May 22nd, 2024, officers responded to an apartment complex and observed the defendant detained by citizens. Complainant advised that he was inside his apartment and observed the defendant sitting in the driver's seat of his vehicle. Complainant got his brother, went outside, and observed the defendant walking away. Complainant and his brother attempted to stop the defendant and got into a physical altercation with him. And at one point, defendant pepper sprayed complainant's brother. 3 other tenants heard the commotion and came outside to also find that their vehicles had been broken into and they were unable to start due to damage to their control panels. One complainant advised that his phone was taken from his car. Defendant was found with the phone and a programming device used to start cars without their keys, and defendant admitted to burglarizing vehicles.
Was the robbery due to the pepper spray?
1 moment.
Everything I was already taken. I don't see where the robbery comes in. He took everything from the vehicle.
Yes, Judge, it is charged, it is pled as spraying the complainant. The robbery.
The theft was
With the intent to obtain and maintain control of the property, intentionally or knowingly and recklessly cause the bodily injury by spraying the complainant with a chemical agent. Not only that, you're enhanced with the felony retaliation. So are we looking at a 15 to life? Jay, is this a 15 to life case? Our case number is 2511-521. Fifth, it's elevated to a 5 to life. I don't know about giving you a PR bond, man. All I care about is public safety, Mr. Haywood, and I don't know if we get it with you. I'm ordering you now as a condition of your bond, if you get out, to remain under home confinement, to have a GPS monitor, not to have any contact with the complaining witness, and not to go within 1,000 feet of this apartment. It's an apartment complex?
Yes, sir.
Not to go within 1,000 feet of this apartment complex. No weapons, undergo random drug testing for alcohol and any kind of dope. Your bond now is set at $15,000 in the robbery case. They give you PR bonds with ours. I don't know if I'm down with that, you know, not with that kind of criminal history and the fact that he just had an assault dismissed of the servant. So guys, please, home confinement, no weapons.
He does work at a tire shop on,
Really?
Yes, sir. My other job was in Dickerson, Texas. It's the same people. I was doing moonwalks and tires, sir.
You scare me, Mr. Haywood. Truly. At 21 and with 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 priors at 21, and now you're charged with 3 cases, one of those being a 5 to life first-degree felony? Ha! I'm sorry, Alan. He scares me. Just bottom line. My only concern is public safety, Mr. Hayward. That's all I care about in this life. You know, you live in Texas. You don't live in Montana, Wyoming. People like their guns and they like their cars. Not a month ago, someone died from a gunshot because of breaking into a car. And the way you look at me now tells me what I can look forward to. All right. Please don't send them down because we need them to sign conditions, please. There's no co-defendant, or was there a co-defendant? If there is no contact with the co-defendants.
No co-defendant.
No co-defendants, there's just him? Got it. You were charged with indecent exposure. You wanted to do the PC on indecent?
Yes, Your Honor.
You're charged with indecent exposure. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
May 26, 2024, officers were dispatched to a defendant touching his private area at the Metro-owned downtown transit center located on 1900 Main Street, Harris County, Texas. The officer was advised by Metro Dispatch that the complainant called and stated that the defendant was exposing himself to her. Complainant told officers that the defendant was a black male in a blue hoodie and boarded a Metro bus, and then ultimately pointed the bus that he had boarded. Individuals matching the description, and complainant witness confirmed that that was the same person. Complainant stated that the defendant followed her from across the street, pulled out his penis, and started exposing it to her and looking at her. She further stated that the defendant began stroking his penis back and forth with his hands, looking at her without speaking, approximately 5 to 10 feet away.
Okay, pause for a moment. This part is important legally. For an indecent exposure charge, prosecutors usually have to prove 2 key things: that the act was intentional, and that it was done in a way that would likely offend or alarm another person. In this case, the entire charge is leaning heavily on the complainant's eyewitness account.
Complainant stated that she was unable to tell if he was erect, but she was able to clearly see his penis as he was stroking.
Your Honor, after speaking with my client, the officers approached 2 males. I have to wait on body cam to see what the other male looked like, but my client's saying that wasn't him. He just...
I don't know. I think that there's probable cause to go forward now. Mr. Lane. Mr. Lane, we will get the body cam to ensure and see if that is in fact you, because we don't know. All we know is that we have someone that has identified you. I will try to have them get the body. Do you have it now? What evidence do you have now?
This is a brand new case, Your Honor. This is the 26th, so I don't know. There's nothing in there, so I literally just wrote this up before I came to court.
Okay, I will, Mr. Lane, I will try to have them get the information and the body cam.
This is actually a really interesting moment. The defense is basically saying, we need the body cam footage first. That's huge. Because right now, the case is built mostly on identification by the complainant. If the video doesn't clearly show the same person, or if there's another individual nearby who matches the description, that could completely change how this case plays out.
Cams as quick as possible so we can verify that it is you. I would say let's try hopefully a week. The problem is that I can't give you a PR bond because you continue to take off on us. I had your evading arrest at 7503 because we can't get you here. So, okay. Do you have any questions, sir? Right now, you're on probation for a felon in possession of a weapon. You're also on probation for possession of a controlled substance in the felony case. You picked up in April with us, you picked up an assault bodily injury. You have literally been given 3 PR bonds and you continue to take off.
I didn't
So,
get PR bond, sir.
but you have. I'm showing that you failed to appear 516.
I just got a PR bond, sir. Excuse me.
Listen to the day.
So Roberto, please don't go. Okay, so I have 3 different occasions that you failed to appear. I cannot, in my good conscience, give you a PR bond when you continue to take off because I know if we give you another PR bond, what's going to happen?
I haven't had a PR bond, sir. I bonded out, and it's the only reason I'm back right here, right now, sir, is because someone took their name off the bond. I haven't did anything else and gotten in trouble. Someone just took their name off the bond because I couldn't get a cosigner. That's the only reason I'm back in jail right now.
I also have that you have failed to appear on 3 different occasions.
I
Okay,
haven't.
so so what we're doing, regardless, your bonds are set at $55,000 upstairs.
And I'm going to make the bond this Saturday. That way I can take care of this stuff
If you
better.
make the bond, I am now going to make you wear a GPS monitor so I know where you are at all times, okay?
Yes, sir.
But I cannot give you a PR bond in this case, okay? Because you just don't show up when we ask you to show up. So regardless, you have Greg representing you now. If you do get out, please stay in contact with him. If you get out, you post bond and you jet on me again, Ms. Gilardoni, I'm going to triple, if not quadruple the bond.
Thank
You
you,
understand?
Judge. Yes, sir.
All we're asking you to do is show up.
All right.
That's it. And stay out of trouble.
All right.
Okay?
Yes, sir.
I know that the felony courts are trying to have you evaluated as well. Do it, because if you don't, the only thing it does is it prolongs your case even more.
Okay.
Okay?
Yes, sir.
I think that we're okay. I don't think that there's,
Okay, Your Honor, thank you.
yeah. So,
I don't think I'm not showing a felony court date for her, but then I was showing,
I am showing 7/29.
okay, you got that 7/29 phone.
Your court date for your felony cases are July 29th. Okay?
Yes, sir.
We don't do that long. Okay, we'll do just 30 days and then we'll come back and then go from there.
Okay, Your Honor, perfect.
Thanks, Steve. Appreciate it. All right, good luck, Ms. Gallardo.
All right. Thank you.
Yes, ma'am.
And this ending really highlights the judge's main concern, reliability. Courts can sometimes be flexible with bail, but repeatedly missing court dates changes everything. From the judge's perspective, if someone keeps disappearing after getting released, the system stops trusting that they'll come back. So the real question now is simple. Will the defendant show up next time? Or will this bond situation get even more serious?